don't hear the music. Okay, the clock is moving. That's good. Well, thank you for joining us tonight on From the Halls of Justice. Our special guest is Miss Wanda Belle, attorney at law, and I love it because you have the same first name as I do. My mother is in the studio with us tonight, and I coaxed her out of the house by telling her, Mom, you got to meet this lady. She's wonderful. Her name is Wanda Belle. So, how long have you been an attorney, Wanda?
Oh, let's see. 1981, I was licensed in Texas, and then I moved out here, and I have been licensed here since 1992, I believe it is. So quite a while.
What made you want to become an attorney?
Oh, that's a good question. No, I don't think anyone's asked me that before. Because it was not my initial career goal.
Really?
No. Wanted to be a fashion designer.
Wow. Well, you look marvelous.
People always be amazed at that, but yeah. I think I just was hanging out with some attorneys and thought, well, maybe I go to law school.
Really? Okay. Well, that's pretty good. So at this time, I know that I met you in family law. So were you always practicing family law, or did you practice any civil or?
Pretty much in California, that's all I did was family law.
Okay.
When I was in Texas, of course, straight out of law school, we did a little bit of everything, just to start a practice.
Mm-hmm.
But, and then towards the end of Texas, before leaving Texas, I was in the office with 4 other attorneys, and I was the family law attorney. So I figured I'd just stick with that when I got here in California.
Terrific. Well, I love family law. I'm only a paralegal, and I just love the ground you walk on. So, someday, okay. We're going to talk tonight about custody and support. So, for any of our viewers, your practice, I know you're well known in the city, and so you practice in West Hollywood, Los Angeles, Riverside, you mentioned. Did you say San Diego too?
Yeah, San Diego County. I have a few cases there. Riverside, San Bernardino, LA County.
Okay. So you're busy.
Most of the seven counties in California.
Okay.
But mostly LA, put it.
All right. And because you're on the show and you're my special guest and you're doing us this great honor, if any of the guests need a consultation, it'll be a free consultation, no cost, over the phone. Don't talk her ear off, okay? Tell her that you saw her from the halls of justice.
Exactly.
Okay. On custody and support, we have people call in, they want to meet with you, they're having an issue. What is joint legal custody?
Well, joint legal custody means a lot of different things to different people, but basically it means that both parents have the equal say in all of the legal aspects of the child, whether the child is educated. They should meet and confer and agree on education needs, medical needs, religion, whether or not they can get a driver's license when they're 15 or 16, a passport, things like that.
Wow.
They're supposed to meet and confer on those issues and try to reach an agreement on those. And when I was in Texas, it was very seldom granted unless you could show that the parties were able to do that. Here in California, it's pretty much granted just right off the bat.
Okay.
Even though the parties can't stand each other and not even speaking to each other. So.
Yes, and we've seen some couples that really just can't stand each other.
Right.
Yeah, it's hard to say, come back, it's not about you.
Yeah. So it's difficult to exercise that right if the parties are not able to come together for the best interest of the minor child and make joint decisions.
Yeah. It's like grow up. Just grow up.
Yeah.
Okay. What is joint physical custody?
Joint physical custody is where both parties share in the physical custody of the child. I guess it's the simplest way to put it. It's if an order just says joint custody, joint legal custody, most people assume that the person that the child resides with most of the time has the physical custody, but that may not necessarily be true. And joint legal custody does not necessarily mean that it's a 50-50 split, which people call me all the time and say, I want a 50-50 split. Well, what does that mean? You know, we can't divide the child down the middle. You know what I mean? So, but it pretty much means that the child is residing with both parents as much as on an equal basis as much as possible. So it's not like a weekend custody kind of an order, although it could be.
Okay. And how does joint legal and physical custody differ from sole legal and physical custody?
So sole legal custody, the party that is parent that has sole legal custody makes basically all of the decisions, the legal decisions, education, medical, and things like that. Even with sole legal custody, you probably should consult with the other parent, but you don't have to as far as the law is concerned. You have the right to make all those decisions. Sometimes you can have joint legal custody, but have sole legal custody as far as education to make the choices regarding the child's education, where they go to school and things like that.
Okay. Can parents have joint legal custody and not joint physical custody?
For sure. Yes.
For sure? Okay.
Yeah, they can, most cases, well, I won't say most because I don't know, but majority of the cases that are joint legal custody, one party has a sole physical. I try to encourage my clients to do both joint legal and physical, unless there's some, compelling reason not to do it. But I think it's good for the child. I think the children should feel freedom, that they can go freely between both parents' home without any restrictions.
So does joint physical custody does it mean that that the child is with each party 50-50?
Not necessarily.
Okay.
'Cause it's just hard to do. And a lot depends on the age of the child. So if you're talking about an infant or a toddler, that may not be the best thing for the child to try to be 1 week with one parent and 1 week with the other. If they were older and the parents live in the same neighborhood and the child will have the same friends, go to the same school, it's a little bit easier to do a 50-50. But like I said, the best custody arrangement is for the children to be free to go to either parent's home at any time.
Now, how does the court determine custody?
The court looks at various different factors, and it has a guide that they go through according to the Family Law Code. The most prevailing guide, I guess, is the state of California, who has determined that it's best for the children to have continuing and frequent contact with both parents. So the court looks at a lot of different factors, though, when determining whether or not they're just going to give one parent that sole legal custody and sole physical custody. And some of those factors could be what has been happening, the status quo, so to speak, with the child since the parties separated, or if they were never married, during the relationship after the child was born, what was the status quo. So there are a lot of different factors that the court will look at to consider child abuse, abuse by one parent against the other parent or the child.
Now, I like this question. It says, what if one parent has been involved in the child's life, has not been involved in the child's life? And that can be tricky too, because what if they want to be involved in the child's life, but you don't get along so well with the other parent?
That's a tough one, and it's hard for the custodial parent to understand because they feel like they've been there the whole time. They've been taking care of the child, and then here comes some, the other parent, be it the father or the mother, and they want to be involved.
Mm-hmm.
So it's emotional and personal for the parents, but for the court, it's not because, like I said, their primary goal is to see to it that the child has frequent and continuing contact with both parents.
Mm-hmm.
Now, you can't be absent and then just walk in and say, hey, I want to start seeing my child. I want my child with me, every other week and, every other weekend or whatever. The court's probably going to put you through a, what they call a step-up plan and just see what your real intentions are and if you're going to follow through. Because the worst thing would be for you to come in and have a couple of visits and then disappear again.
Mm-hmm.
And there are various reasons why parents are not involved. Sometimes they're incarcerated or they're out of the state or, like you said, the parties just don't get along.
That's difficult. And what if one parent has a history of drug abuse or alcohol abuse?
And that's tricky too. That's per se not enough to preclude you from having custody of your child or having
supervised though, right?
Not necessarily. It depends on a lot of factors like the history. If it's alcohol, well, in California now, I had a judge the other day says he doesn't care about marijuana in your system.
Well,
because it's, I guess, kind of legalized.
They've legalized it, right?
So, but it just depends on how long ago the person was involved with alcohol and drug abuse. A lot of the factors. There are a lot of orders that say you can't drink,
Mm-hmm.
within so many hours or during the time that you have the child.
Mm-hmm.
And they can't really order you to have drug testing, but sometimes the parties will agree to drug testing just to prove that they're on the up and up and they're not involved in drugs. So,
Mm-hmm.
but it doesn't per se preclude you from having custody of your child. It is an issue that has to be dealt with,
Mm-hmm.
but it doesn't preclude you from having the custody and visitation.
Now, does the court require parents and child to go to counseling?
Sometimes, especially if there's been a long period of time where one of the parents has been absent from the child's life,
Mm-hmm.
and they have what's called reunification therapy, where they try to reunify the parent
Mm-hmm.
with the child. There's also some other forms of therapy that court can require all of the parties to attend, parenting classes, and if there's been issues of abuse, definitely the abuser is required to go to domestic violence classes and what is it called, batterers class, I think it's
Really?
called batterers intervention class, things like that. But for custody issues, sometimes counseling really helps, and it helps the parents to sometimes put aside the anger and all of the other issues
Mm-hmm.
and focus on what's best for the child. It's hard out here to raise a child. You really need both parents.
That would be
if
great.
possible. Yeah.
It would really be great. It takes a village.
Yeah.
Can a third party get legal custody of child if both parents are living?
Yes.
We're talking like grandparents or an aunt or
Grandparents
relative.
or aunt or someone that's been caring for the child.
Mm-hmm.
But there's a burden that you have to meet, and it's a pretty tough burden. You have to show that for that child to be with either one of the parents, it would be detrimental to the child.
Mm.
So, and a lot of times you can show that because the parents may be involved in drugs. You see it on the news every day. Both parents are addicted to drugs and they neglect the children and leave them, at home alone and car alone, abuse them in certain ways. So it's not a hard burden to overcome in some cases, but in some cases it's just where the parent is in and out of the child's life, leaves it with the grandmother because they know that grandmother's going to take care of everything, and they run back in and run back out, and then grandmother wants to go in and get that custody
Mm-hmm.
of the child, and it can happen.
Yeah, it's hard because you fall in love with children and to take care of them and love them and provide for them, And then to have somebody, not somebody, but their parent just show up and then take them away from you like that,
Yeah.
it can be really hard.
It's really, really hard. So the courts are aware of that. They see all types of cases and hear all types of stories. So they look at everything, and we try to present the facts to the court so they can really get a clear picture as to what's going on in this particular family's life.
And now I like this. Would a person have to pay child support if they have 50% of the time with the child?
Yes. We get that question all the time. Yeah, so it's possible because there are a lot of factors that go into calculating child support, not just the timeshare. Timeshare is something I think is maybe unique to California. We didn't have that in Texas that I can remember. But so the percentage of timeshare has an effect on the support here in California. So a lot of people are juggling around trying to get more time, and the other parent is trying to get less time. So it'll have an effect on the support.
So what if both parties are making equally maybe the same amount of money?
If they're making, it's a formula, and here in California they use a computer program. So
A DisoMaster?
the DisoMaster, and there's some other ones. I think the state uses support calculation, or I can't recall the name of it, but there are different ones, and there is a formula though that the code provides for, but those formulas are calculated by using these certain programs like the DisoMaster. So most people want to know if I have the child with me 50% of the time, why do I still have to pay? And a lot of that is based upon your income and a lot of other factors.
What if the other parent decides to waive that fact?
Waive which fact?
That you don't have to pay support.
You can do that, but it's only, I tell people that the agreement is only as good as both parties are still in agreement.
Okay.
I can agree to that today, and as long as the child is under 18 years old and not in high school, the court has jurisdiction to modify that, and they can make the order. So I can agree to no support today, and a month or two later come back and say, hey, I want some support. So.
Okay, things are subject to change.
Exactly.
Or if they're doing very well, bless their hearts.
Yeah, I just did one recently where the parties both, they both support the child, and they pay for the private school, they pay for all of the activities, and so they agree to no child support order because they're both doing it. So.
Okay, well, does the parent receiving the support have to show the money that's spent for the benefit of the child?
Well, I get a lot of guys that ask me, especially guys, and don't so much women, but guys that, what is she doing with that money? I guess they think they're going to get the nails done, and the hair done, and everything done.
Right.
But
I think they don't mind paying for their child. They just don't want to pay for her.
Right.
Yeah.
Right.
So that she can look good to somebody else.
Right.
Yeah.
Right. So I try to explain to them it's, she doesn't have to account for the money. And I try to be as blunt as I can by saying she can take the money and flush it down the toilet if she wants.
No.
Because, I mean, that's a little extreme, but I'm saying, she doesn't really, or he doesn't have to account for the child support because the assumption is that if the child is with you, you have some expenses. You've got to get a bigger place. You can't live in a one-room place. For the most part, your electricity is going to be higher, your food bill is going to be higher, your gas is going, you have expenses caring for a child, so you don't have to go and enumerate those down. If there was probably a situation where the child was, really being neglected, that might have some bearing on it.
It seems that, a lot of the times the judicial council, I look up to you, and my judges, I look up to my judges, and Judge Cunningham is very civil-minded, and he's a wonderful man. He's my hero. Judge Craig Mitchell, he is an awesome judge, and he does the marathon running. I got caught up in the spirit and thought I could marathon run too, and found out I needed to sit down and just cheer from the side. I could do like a 3-mile thing. Judge Diaz, he loves CASA. And so during the time, one of the interviews, I was really blessed during the summer and part of the winter, it turned out, that I had 3 beautiful girls that ended up staying with me because their mother was going through a transitional period. And I figured out that, I basically gave up my shoe money,
Right.
And I have a lot of shoes.
Yeah.
But those girls, they can cost a lot of money.
2 girls and they're very
Oh,
expensive.
yeah. I was like, oh my God, they're so cute. Oh my God, they cost so much, So
Raising children is very expensive. So,
it really is.
I would not encourage any of my clients to even go there and say I wanted to account for every penny or him to account for every penny, because it's expensive to raise children.
Yeah.
And most of the time, the support is not enough.
Well, bless their hearts. It was a real experience. It was a treat and something I'll never, ever, ever forget.
What I want to add to the child support is that I have clients that are, professional athletes, or, they make a lot of money. Some of them make a lot of money, that are, doctors or other professions where they make a lot of money. And maybe the other party doesn't make quite as much.
Mm-hmm.
But the law says that they have to support their child based upon that standard,
the lifestyle they've
that,
become accustomed to.
Right, or the lifestyle, the parents, ability to pay and the lifestyle. So it doesn't matter that it may benefit the other party, it may increase their lifestyle as a byproduct of that. But a lot of people, of course, they have a hard time understanding that.
Well, what happens if a parent ordered to pay does not pay?
You have some serious enforcement issues. It's really easy if the parent is a W-2 wage earner. You just send a wage garnishment to his employer and have it come straight from his paycheck. If he's not a wage earner, if he's self-employed or something like that, it's a little bit more difficult because you have to try to track the money and find out where the money is. The County of Los Angeles will do that for you. Child Support Enforcement Department will try to enforce some of these support orders, and I usually will send a parent there if her finances are limited and she's not able to legally pursue or enforce a child support order.
Now, I didn't know this. Is this true that a client informed us that she wanted to go to child support services, but she changed her mind because she said that they charged her a percentage of whatever she was going to receive?
That is not my understanding, and
Okay.
I haven't really had a lot of doubt. Well, I used to be on the panel over there and for child support enforcement. I didn't work for child support services department. I was the one that was defending the person that they were bringing in to get an order for support.
Okay.
But I never heard that before. They do
I haven't either.
Yeah, they if the mother's receiving aid, then the county or the state is reimbursed for that from the child support money that they collect. But as far as charging that percentage, if that is the case, that's something that's new.
Okay, so if the mother is receiving aid from the state, then the child support money that she gets, they take money out of that to compensate for the money that she's on welfare for or something?
Yeah, it's reimbursed to the state. So, but
I didn't know that either. I mean,
Yeah, so most of the time in those situations, not always, but the mother is, or the custodial parent, I hate to keep saying mother, but the custodial parent is receiving more in aid than what they would be getting from child support.
Wow.
A lot of times in those cases. So whatever, for instance, if the mother is getting, say, $600 a month from the state, and the child support order, they don't order the non-custodial parent to pay $600 a month. They order him to pay based on those guidelines and what he can afford to pay.
Because
so,
I was going to say, because sometimes they're not making that kind of money.
Right.
I was
so if he's ordered to pay $300 a month and she's getting $600, that $300 is going back to the state.
Oh.
She gets the $600, but not the $600 plus the $300.
Okay. All right. I know we had a case that it wasn't child support case, it was spousal support, and it was a long-term marriage. And it's a really cute story. He's in his 80s, and he started dating his 40-year-old nurse. And she, the ex-spouse, all of a sudden she said, I was receiving my money like clockwork the first of the month. And all of a sudden he stopped. And he stopped because he figured that now all 3 of their adult children were grown. And if each adult child paid $300 apiece, that they could support their mother. And he was going to take his money and live happily ever after with this woman. Unilaterally, he made this decision.
Right.
Yes. So the judge said no, he couldn't do that. Yeah. and he apologized very quickly and started sending the check again.
The money. And I'm sure the children weren't in agreement
the
to
children.
that
Oh my God, it was hilarious. Okay, well, we're down to 2 minutes now. What if a parent is hiding their income?
That's very difficult because it's hard to find money that's being hidden by a parent, especially if they're not putting it in a bank account and they're putting it in their new spouse's bank, running it through their spouse, some running it through their parents. So it's a nightmare for some moms, and it can be very costly to try to locate that. So there are other ways that you can improve their income based on their lifestyle. They're driving a Mercedes and they're living in a nice big home. And
now, see, I'm going to call her a friend because she's a very nice lady. And I was really surprised. There was a couple, very nice couple, and she was a higher wage earner than he was. They both had their own businesses. And he still was imputed with a certain amount of income because they were not married. They were living together. And I'm sure this was a deterrent for her to marry him at this point, but she got herself a new Maserati. But she said it was because she got a good deal. She was leasing it. And she said the guy who leased it to her gave her a good deal versus the Lexus she had.
Right.
And so when the ex-wife drug him into court, she said, but he's driving a Maserati. He wasn't driving the Maserati. The girlfriend was driving the Maserati. So they hit him with some income.
Right.
It was so sad.
There are other ways to prove it, and lifestyle.
But it wasn't his car. No.
Well, the courts can also look at loan documents. So a lot of them will say it's not their car, but if you look at the loan
is that what happened? Oh, he messed up. No. Oh, judges are kind of smart. Okay. Well, Wanda, thank you so much for being with us today on From the Halls of Justice. It's been wonderful having you. And once again, if anyone in the audience wants to reach out and have a free consultation, they can give you a call. Wanda Belle, that's Belle. And join us next week on From the Halls of Justice.
Thank you for having me.
Oh, the loan documents. Okay.
So did we run out of time?
I told you it was going to go fast.
So what did we miss? So did you go in and edit or?
No. Are you kidding? Leave everything in. Yeah, no, we're going to leave everything. That was good.
You think so?
Yeah.
I kept saying, and